the next question I have for you is, before entering the hearing room, like, what happens with non-represented claimants versus represented claimants?
Okay. Yeah, so basically, when you guys enter the hearing room, before you enter the hearing room, I am the first point of contact with you besides the security guard. You're going to come in, you're going to check in with the security guard and give them your name, the fact that you guys are here for a hearing, and what time it's at. You're also going to be meeting with, if your attorney is there already as well. And so what happens is you check in with the security guard, and then you're going to go into the lobby. I'm actually going to go check in with the ALJ, the judge, and tell them that, the next hearing has arrived. And then I'm going to come and check in with you guys. I'm going to ask you some of the basic information. I'm going to ask you your name, your address, your phone number. Just want to make sure that everything's up to date. And we also want to, and that's basically for everyone, whether you're represented or you're not represented. That is the, the basis for both. Even if you guys have an attorney. So I'm going to gather all of that information. If you guys have any witnesses or supportive roles, I will also go ahead and take their name in relation to you. And I'm going to go into a little bit about what a witness versus a supportive role is. A supportive role is someone who is there with you that you feel comfortable with, that can sit in at the hearing with you. Kind of like your hand to hold. What kind of car I drive is a blue truck. And then, your mom, who is your supportive role, is like, no, honey, it's a red truck. They can't interject at all. So that is a supportive role. If you want a witness is just like, probably the basis that you guys understand on TV and such, that they are able to speak on your behalf. They are able to testify on your behalf. Now, the difference is, we do have to get the ALJ's permission for you guys to have a supportive role or a witness. And every ALJ is different. They all work different. They are the boss of the room, but they work very differently. Some will allow them, some won't. And it also depends on, usually if you are not represented, you guys probably won't know this, but you want to send in a request to have a witness, because basically we have to allot time for you guys to have a witness there, a supportive role, because it will take more time than just the 30 to 45 minute testimony with you, an attorney, and the judge. We have to allot for more time. And again, for non-represented claimants versus represented, this is all the same. We still have to get the witnesses' names, the supportive roles' names, and their relation to you. Also, one thing I want to add in, if it's a kid case, you guys have to have the legal guardian that filled out the paperwork come to the hearing. I've had a hearing, before this whole pandemic thing and everything spun out of control. I actually got a kid case, and the mother was sick, and so she sent in the grandmother, and my judge said that they couldn't have the hearing because the grandmother is not the legal guardian. So you guys have to have the legal guardian come into the hearing for a child that is under 18. They are considered a witness, so I still have to get their name and their relation to the child or, whoever is going into the hearing. Also, for a non-rep claimant, it's a little bit different. You guys don't have attorneys, and if it is your first time coming into the hearing, then you and I are going to go sit into a conference room. There should be, especially for for Florida, we have 2 conference rooms, and so that is for the attorneys to have, a little consultation sort of thing, conference with their claimant right before the hearing, to try to refresh their memory on, the testimony shaping questions that are going to happen. And then those are rooms also that I meet with the non-rep claimants. So I sit in there with you guys, and I have a CD with me. It has all of your medical records on there. Now, the SSA is supposed to send you non-rep claimants a medical record CD in the mail. Does it always happen? No. But I always have a copy with me that day to show you guys. Now, we can't go into every single section. There's A through F as far as evidence, and they all are categorized differently. But what we do is we go to the F section, which is the medical record section, and we just show you a brief description. We show you a summary of a description of the record. We show you where it's from, and we show you the dates of service, because we want to make sure that everything is there for you, that you turned in, that we're not missing anything, and that they all belong to you. Because at the end of the day, right, technology can be crazy, and, sometimes it fails us. So, medical records will go into the wrong file, or they won't be yours, etc. So we have to make sure it's yours. And so we'll go over all the medical evidence. And if you did bring any in with you that day, that's fine. I will say the judges don't like that, just because they want to give you guys a fair shot. This is like your once in a lifetime chance, and that's how you guys have to see it. It is not, there's no do-overs. There is do-overs. If you get rights to representation, that's going to be the first question that the judge asks you when you get in the room. If you want to waive your rights to representation and represent yourself, or if you want to go ahead and postpone to try to find an attorney, you are able to do that. The judges will give you a one-time postponement, but the next time you come in, if you do not have an attorney, then you have to go forward and represent yourself. So I'm going to go over all of that with you for a non-represented claimant, and then, we'll make copies of any evidence that you brought in. Just like I said, the judges want to look it over. They don't want to skip out on anything. They want to give you a fair shot. So, if you can, always, please try to send in your evidence as soon as you get it. Fax it, mail it, drop it off. It doesn't matter. Just, try to have it in before your hearing date. Don't just come in and throw up a bunch of evidence, because the judges don't like that. But we'll also, if you are missing things, right, and you don't have it with you, then I'm going to have you sign an 827. It's a medical release form from the SSA so that we can actually get records on your behalf. And so that's basically it for a non-rep. For a represented claimant, it's the same thing. Gather info. Most of the attorneys are really great. They aren't coming in the day of and turning in evidence. It does happen, but for the most part, they don't. If they were to, then, again, the judges aren't really favorable to that, only because the attorneys have a 5-day rule. They have to have everything submitted normally 5 days before the hearing. So, again, if you are represented, do your attorney a favor. Like, Walter is so busy. He has tons and tons of claimants. So, not to say he's not on top of what he needs to do, but he's one person. And so if you guys have an attorney, if you guys have a record, if you guys went to a doctor and you know that it's missing, try to get it to him. Try to get it to your attorney as soon as you can, or tell them about it in advance. Because when you guys get into the hearing and your attorney turned in all of this stuff on that day, the attorneys know this already, but it doesn't look favorable. The ALJ is going to beat up the attorney and talk about the 5-day rule and why was it late and yada yada. And then I'll gather any legal forms from the attorney. So, like, I'll just give 2 examples. Basically, an amended onset date form. So that is your onset date is the date that you became disabled, right? So if for any reason the attorney has to amend that date, then there's a form that has to be filled out. So a lot of times they will have those filled out prior to the hearing, and they'll hand that to me. Or closed period forms. I know in most of the lives, you know, you guys are not going to know all these forms, but you know, a closed period form is basically, in terms of Social Security disability, it's the time between the onset of your disability and the time when you were able to return to work. So basically, that's you asking for disability just for a set period of time because you went back to work. So those are the kind of forms that the attorney would submit to me, hopefully before the hearing. Some of them do it during, but basically I'm just going to gather all the information, show you guys the evidence, and then when the judge is ready, then we're going to go ahead and go into the hearing room.
Okay, excellent. So I just want to point out, she's absolutely right. Now here's the deal. I always do a 5-10 day letter before the hearing to notify the judge if I have a complete record or a not complete record. But the deal is this: if I'm going in there and my client hands me paperwork ahead of time, I'm hoping that the judge's, in this case, clerk / the person that's going to be doing the transcription, I'm hoping that's a buddy of mine who just handed it to him, because otherwise the judge rooms me out. I mean, beats me up and down. There's a left side of the room, a right side of the room. I'm in the left corner. I'm just kidding, but it's horrible. They beat you up. They just maul you, these little judge paws, and it's terrible, but it's okay. Actually, my dogs are now trying to come up and kiss me. So with that said, hi, Shadow. With that said, I want to ask you this. Okay, so that's really good. That's what happens before the hearing.